Good morning, ladies and gentlemen. My name is Steve Hill, and it is my honor to be the judge presiding on this panel of the Court of Appeals. I have the pleasure of serving on this panel with our most senior judge, Judge Perrin to my right, and our most junior judge, Judge Schroeder, to my left. I'll let you in on a little secret. He is known as the baby judge, which is something that we may call him, but you may not. But we thank you for coming in today. We will take up the cases in the order in which they appear on the docket. I have seen that no extra time has been granted, but counsel, if you represent the appellant and wish to reserve time, please let me know and I'll be sure that you get that. We have read your briefs. We have received a memorandum from our research staff concerning each case, and we have read that as well. So I would suggest that you, with the limited amount of time that you have, get right into arguing the issues that you want to persuade us with, rather than spending a lot of time on the facts, because we're fairly familiar with them. Previously, we had sent out, and this is for the students, and for those of you who wish to remain after the oral arguments today, we will be glad to answer questions for anyone who remains. Of course, we cannot discuss the cases that we hear this morning, but if you want to ask us questions on how we go about our business and do things, we would be happy to do that for you. But one of the things that was sent out was a brief synopsis of each case, and the first case that we have on the docket is Jesus Rodriguez through his natural mother, Graciela, versus the Unified School District number 500. Mr. Rodriguez, a member of his high school soccer team, was injured during a car accident on the way to a school soccer game. He was traveling in a private vehicle with another student. When he attempted to obtain coverage for his injuries under the school district's catastrophic injury insurance policy, the insurer, Mutual of Omaha, denied coverage. The district court upheld the denial of coverage, ruling that his travel was not covered travel as defined by the insurance policy. So with that in mind, we will take up our first case, which is Jesus Rodriguez versus Unified School District 500 and others. Counsel?
Good morning. My name is Henry J. Watson, and although I've been practicing law for about 42 years, it was only recently that I was admitted to the Kansas bar.
Well, welcome.
Thank you.
It took you a long time to get here, but...
A very long time from across the border.
That's right. Good for you to get here.
So it's a real pleasure and an honor to appear on behalf of Mr. Rodriguez in a very, very tragic case, as was just pointed out.
Do you wish to reserve any time for rebuttal?
Yes, thank you. I reserved 3 minutes, 12 and 3.
You've got it, counsel.
Thank you very much. The appeal involves interpretation of an insurance contract and applicable statutes, if any, and therefore this court has unlimited review of questions of law. We're asking this court to find that there is coverage and reverse the judgment of the district court granting summary judgment to Appellee Mutual of Omaha.
Counsel, I've got a question for you. If, as I understand it, this was a declaratory judgment action.
It was, yes.
But I see in the record testimony from insurance agents and others giving their opinion about what these things meant.
There was a trial.
School practices on the customs about allowing students to drive themselves to sporting events, all of that sort of thing. But what does that amount to in a declaratory judgment action?
Well, it formed the basis for the court to then determine whether or not there could be coverage under the terms of the policy, the defined covered travel.
But as I understand a declaratory judgment action, it's based upon an interpretation of the contract itself. Surely you don't need all of that other extraneous evidence to interpret a contract.
In all candor, the court could have decided, in our view, the case without any of that testimony.
And the statutes.
That's right. But a bench trial was set, and of course, we were obliged to appear and present some evidence rather than just make arguments.
Well, I'll be sure to ask your opposing counsel the same question on why all of that was necessary.
Sumner Academy, although it provided buses for most of these games, also allowed and permitted schools, children, to drive themselves and drive other kids to the games. In fact, they sent an authorization form to the parents so that the parents could give permission for the children to either ride or drive, or there were any number of different scenarios, and they had to check the different parts of the form that they would authorize the kids to travel.
And we had such a form in this case?
Yes, it's one of the exhibits in the case. It's unfortunately I think mistitled transportation release form. It's not a release. It's a permission form, and it's quite clear that what was intended was permission from the parents so that children could either ride or drive to school depending on the circumstances.
And remind me of the position of the school district if one of those was not signed.
This one was signed, and this.
But if it was not signed, what was the policy?
It was not signed. The school district quite clearly would not permit the child or the student to either ride or drive in anything other than the bus. They had to.
So he would have been required, if they didn't have this form, he would have been required to be on the school bus that was provided.
Precisely. That was part of the coach's job, to ensure that the kids who got on the bus didn't have the form, and that only the kids who had given him previously a form signed by the parents could either ride or drive to the school game. What's at issue here, really, is whether or not the school, in this case, authorized Jesus Rodriguez to ride with another student to the soccer game in question. And secondly, whether the expense for that transportation would have been subject to reimbursement had a claim been made.
That's because of the clause in the insurance policy that says authorized travel, which is subject to reimbursement.
Yes, Justice Hill. And in drafting the policy, Mutual chose not to define authorized, but then used the narrowest possible interpretation of the word to deny coverage by concluding that Sumner Academy could not legally authorize a student to ride with another student unless they were accompanied by an adult.
Is this a statutory provision?
There is a statutory provision that pertains to bus transportation. It's 8305, and it's the one that my worthy opponent is relying on.
So there is a state law saying that you have to have an adult with you in order for the transportation to be reimbursed and approved?
No, there is a state law, it's case 872-8305, which deals with providing and furnishing transportation to activities such as a soccer game. The entire statute, except for one section, pertains to school bus operation. And it authorizes districts to reimburse for the expense of bus operation to and from these games. It permits the district to adopt rules and regulations for the conduct of buses. And then at the very end, it says, all students so transported shall be under school control and discipline and so forth. And just before that, it requires that students be accompanied by a suitable adult, but only when they're transported by bus. This is what the statute deals with.
Now, the district court didn't agree with your interpretation.
No, on the contrary. The district court found that this statute would only permit transportation if an adult was accompanying. And it would make sense that if you have 20 kids in a bus going to a school game, that there be an adult.
Let me ask you this. Under your view of this, under your interpretation of this statute, say the debate coach puts 4 of the debaters in her personal vehicle and drives them across town to a debate tournament. Is that authorized? It's a school event?
It's authorized as a school event, and it would be subject to reimbursement in our view, and it's something that occurs in the state of Kansas in the rural districts all the time, where they don't have the money to get buses to transport kids back and forth to games or to debates. It's a daily occurrence.
What would happen if she didn't accompany them, and maybe she accompanied 4 and told 4 more, well, you just get yourself over there the best way possible? Would those that she did not accompany, would they be covered by insurance, by the insurance policy?
They should be, if they were authorized, and on your question, I think they would be authorized to go to the debate, because 728301 specifically grants the district authority in subsection 5 to reimburse persons who furnish transportation to pupils, students, or school personnel in privately owned motor vehicles. And that's really what we have here. And doesn't.
So if they're on a bus, they have to have an adult with them, but you claim if they're in a private vehicle, you don't have an adult with them.
There is no statute that says that if they're in a private vehicle, they must be accompanied by an adult. And there's another important point which I think is determinative here. The insurance company defined covered travel to include individual travel. It says team or individual. These were their terms. And so it's certainly reasonable to conclude that they anticipated students would be transported to games and other activities, either by other students or they would drive individually. In any event, by not defining the term authorized, the insurance company gave itself tremendous latitude to then deny coverage, as it's done in this case.
What are our rules of construction of insurance policies call for?
Well, that in circumstances like that, it's quite clear that the construction should favor coverage rather than denial.
Counselor, my big problem with your particular case is the second phrase, subject to reimbursement.
Well,
How was this transportation subject to reimbursement?
well, it was subject to reimbursement because 728301 specifically grants authority to the district to reimburse. And then what is subject to reimbursement? The other side takes the view that the expense had to be reimbursed for there to have been coverage in their brief.
But doesn't this school district have a policy, a published policy that says we're not going to reimburse drivers that are under, if I recall correctly, 21?
The school district has a guideline that mentions that, not a policy. And any of
Well,
it,
enlighten me then the difference between a guideline and a policy.
I think the policies are the law. A guideline is simply something that is meant to provide help in then enforcing the policy.
Guidelines are what my kids want me to have, and I think they're policies. Is that it?
No. Well, no, but in this case, the policy that you have in mind, I think clearly was intended for circumstances where the school is arranging for the transportation. They're going to go, for instance, on a field trip. It's in the public interest to make sure that all those children going to a field trip are fully protected by insurance coverage. And so the rule requires that an adult accompany them and that there is verification of insurance. That makes perfect sense to me. At least, and that's what the executive director of services testified to in this trial, that it was only intended to cover circumstances where transportation was being arranged by the school.
In looking through this record, the school officials that testify seem to me to take great pains in not to ever use the term authorize, but sure did say permit a lot,
Or allow.
or allowed. What's your view of that?
My view is they're basically synonymous. This is no different than something we're all familiar with, which is the consent policies, liability policies that we have for our own vehicles. In order to invoke insurance, all that is required is that we consent to someone else operating our vehicles. We authorize it. We permit it. If it turns out that the driver involved in an accident was a minor and unlicensed, the insurance company is not going to be hurt to say, well, you should not have allowed a minor, an unlicensed minor to drive, and there is no coverage because that was illegal. And all that the insurance company is requiring in this case is that the trip be authorized, not by Kansas law. They could have said that if they wanted to. It must be authorized under Kansas law, and perhaps they would have a better argument. All that they required was authorization by the school, and it's undisputed that the school authorized this form of travel.
Under your view, if Jesus had driven himself and had the accident, would he have had this coverage?
Well, certainly, because as I mentioned, the policy defines covered travel as individual travel. This is what the premium was paid to cover, individual travel.
Doesn't the school policy also give discretion to the principal to allow reimbursement?
Well, precisely. And there is a student activity fund pursuant to statute that authorizes the district to reimburse this type of expense. Now, you will hear from the other side that there's been no history ever, at least in this case, known where an expense was reimbursed. Perhaps not in this district.
You are getting into your rebuttal time.
Thank you.
You can go ahead and finish answering his question.
No, in this district. But I can assure you that if you go to rural districts, these reimbursements are made routinely because there is no other form of transportation except students and parents. Thank you.
Good morning, Your Honors, and thank you for having us here this morning, this very convenient location for me. Obviously, I represent Mutual of Omaha, the insurer here.
You're Robert Hoffman, correct?
That's correct.
You have a
And-
bar number?
Yes, it's 16453.
Thank you.
And unlike Mr. Watson, I have actually been licensed in Kansas my entire career. So
Congratulations.
Thank you.
So have we.
It's just not as long a career as his.
Our numbers are much lower than yours.
That's what I was guessing. The trial court did not err in determining that the travel was not covered travel within the meaning of the policy. The trial court correctly applied the meaning of the statute and the meaning of the policy.
Really? You now have the trial court saying that the only authorized travel that a school district can authorize is if a 21-year-old is accompanying them. Is that correct?
It's not the trial court that says that. It's the Kansas legislature that says it in Section 728305. And it doesn't say it as broadly as that. It certainly, there is a provision, a separate provision.
Well, the trial court certainly said that. It certainly held that's the only way you're going to authorize travel is with an adult with them.
For activities, that's accurate. For activities for schools, that's consistent with the statute. And where it's authorized and paid for by the school, it must have the accompaniment of a 21-year-old, of an adult.
Where in your policy does it incorporate that particular statute as part of your definition of authorized? Of course, there isn't any definition of authorized in the policy, is there?
You're right that there's not a definition of authorized in the policy. It's through the provision of covered travel that's required to be both subject to reimbursement and authorized, which means it at least, at minimum, has to be legal under the state rules for the school to pay a reimbursement request if one were made.
But there's another statute that deals with reimbursement, doesn't there?
There are a few other statutes that deal with reimbursement for some types of things. One of the ones that the appellant cites is 12105B, which is the procedure for obtaining reimbursements, claims under the Kansas Payment of Claims Act. And that provision does not apply to activities transportation for this type. There's no grant in that statute anywhere, and not really even a suggestion of a grant in that statute that mileage could be paid to a student driving another student.
I want to make sure I understand your argument. Are you saying, well, how do you view subject to reimbursement? That it must be legally reimbursable, or if it is a discretionary act of the school district? In other words, if they have the discretion to pay it.
Our view is that it at least must be legally reimbursable. At a very minimum, it must be that. But really, it should be, they should have the discretion, and there should be some evidence that they would exercise that. In some instance, the exercise of discretion would be to actually pay the reimbursement.
I promised your opponent that I would ask you the same questions. This is a declaratory judgment action. And is that correct?
It is. It was the plaintiff's declaratory judgment action, yes.
And so what was all of this testimony from insurance agents telling the judge what they thought the clause meant, and the school officials telling what they've done and what they authorized? Surely in a declaratory judgment action, you interpret the contract probably in light of the applicable statutes, don't you? What was all of this other for?
It's an interesting question, and both parties objected to some portions of the procedure, different portions, of course. But essentially, I think what was happening in the trial court, and it's something of a guess because the trial court didn't tell us why he chose the procedure that he wanted, but is that he wanted to assure himself that if he found there was ambiguity in the policy, he had gathered all of the evidence, the parole evidence that might be available, and he had a full amount of information upon which to make a decision.
Now, you've just used a term that just, I could hear teeth setting on edge on either side.
They were mine.
Yeah, when you said parole evidence to vary the terms of a written document, is that?
That's true.
We can't do that, can we?
Well, I don't think it's appropriate. I think the terms are clear and unambiguous, and that was our position below, and it's our position here, that the terms of the statute and the requirement of being subject to reimbursement plainly require it at a minimum be consistent with Kansas law, which it's not.
You would agree, would you not, that our rules of interpretation, the appellate rules of interpretation of an insurance contract, means that we try to interpret an agreement to provide coverage, not to deny coverage. Is that correct?
I would agree that's the general standard. Of course, it wouldn't be appropriate for the court to do violence to either state law or to the terms of the policy in order to obtain coverage.
I understand your position that under this particular case, we should interpret it to deny coverage.
You understand my position
Yeah.
exactly right.
But given that, you really haven't defined authorized in the policy, and this is your policy, you wrote it. Well, not you particularly, but, you know, the lawyers back at Omaha.
The Mutual Omaha attorneys presumably created this policy, and
they could have defined this.
you're right that there is not a definition of the word authorized in the policy.
Authorized by state law. I mean, 3 more words, by state law, and this would have been a slam dunk, close the door, probably wouldn't even had a declaratory judgment action, right?
I would point out to the court that both provisions are required in the same clause, authorized and subject to, paid for, or subject to reimbursement. And it's the subject to reimbursement portion that trips the state law, not necessarily authorized. The authorized provision, I think, and our view is triggered and offended by the school policy statute, which plainly says use of private automobiles for field trips and activity transportation shall not be authorized, except, and then it goes on to provide circumstances, but it always requires a driver over the age of 21, which is not exactly consistent, but parallels the state law requirement there be a suitable adult person in a vehicle if it's subject to reimbursement. So the two concepts tie together fairly nicely for that point.
As I told your opposing counsel, my difficulty in your case is, first of all, the interpretation of the statute to be so restrictive that school districts could only provide transportation if somebody, an adult 21 years or older, is involved. But I'm more interested now in this subject to reimbursement. That's the part that, talk to me more about that. Tell me what,
Let me try to address both. I think that they're both addressed in the statute 728305, which is defined in part by the definitions of 728301C, which defines the phrase provide or furnish transportation. And that says, the statute says that a school district may provide or furnish transportation to activities. That's what 728305 is, which is different, of course, than providing or furnishing transportation to or from school. And there's a different statute that governs
Certainly.
the to or from school provisions. It's
and,
much,
and we have cases dealing with to and from school.
we have a number of those, and they're much less restrictive. In those cases, it's plainly true that an individual could drive himself and be reimbursed and could obtain a contract for it. And that statute is governed by a different set of rules. But activities which are not mandatory, which are not required by the state, which are purely voluntary by the participants and purely voluntary by the school and school districts, have a more restrictive, appropriately, have a more restrictive standard. And in those cases, the school may provide or furnish the transportation. It's discretionary. And it may pay for it if it does it by bus. And in all cases, however, if it does it, it must, the students so transported shall be under school control and discipline, and in every case shall be accompanied by a suitable adult person. And that may not.
Counsel, why shouldn't we interpret the phrase subject to reimbursement to mean that it can be reimbursed? The district could reimburse it, but they don't have to.
Well,
Which would make it a more loose definition.
if we defined it as broadly as that, we would strip it of its meaning, because particularly if we were to, in that analogy or that concept, allow the school district to violate the provisions of state law by the reimbursement. And for instance, if the school district did provide reimbursement, it would be within the definition of 728301, providing or furnishing transportation. If it paid for it, it would have provided or furnished the transportation, in direct violation of 728305.
The difficulty I have with that is that the school finance law allows school districts to establish an activity fund. And that activity fund is collected and paid at the discretion of the schools. And so you would agree, would you not, that this activity fund, if the principal here wanted to reimburse Jesus for his providing his own transportation to the soccer game and back, he could have?
I don't think he could have without violating state law, Your Honor. And the reason is that the activity fund, which is a different statute, 728208A, that the provision that allows for the creation of an activity fund does not mention transportation at all. Doesn't talk about
But
allowing.
that doesn't exclude it.
That's
the whole purpose of it.
The direct reference to 728305, which includes transportation, which defines how and when and whether it may be provided, how and when and whether it may be paid for, and the particular restrictions required by the legislature for student transportation, specifically to activities.
And that
governs.
And I totally agree with you, because even the title of that statute says bus transportation, and I agree with your interpretation that applies for bus transportation. You know, if I had 40 kids on a bus, I'd want some adult on there. to tell you the
With
truth.
all respect, Your Honor, the title of the statute is transportation for activities. And our position is it governs all transportation for activities. And it's not the activities fund, which might be utilized to pay for some aspects of, equipment for the activities or things like that. And
Or the
within
debate coach
discretion.
driving them across town.
That's transportation for activities, and it's governed by 728305. And if
And you're telling me that the school district wouldn't have the discretion to pay for transportation out of the activity fund?
I'm telling you that in my view of the statute, the legislature of the state of Kansas has made that illegal because it's restricted the method and manner in which payment can be made for those things.
Your view then is that the school district cannot do anything unless it is expressly permitted by statute.
Or clearly implied, and that is.
And we've got an
plainly-
activities fund that they say, school district, it's your discretion.
It's your discretion to handle some costs of activities, but not your discretion to spend in any way you want. If we allowed the principal discretion, unbridled discretion, to do anything they wanted, they could presumably pay for illegal things, they could pay for gifts, they could and none of that would be
I fully understand
permitted.
that, counsel. I mean, we have cases all the time about people spending money that they shouldn't.
And if it were paid for out of the activities fund, merely at the discretion of an employee without any restriction in state law or foundation in state law, our view is it would be violative of the law. So,
Well,
the-
counsel, you've got 2 minutes.
and the only other point that I have beyond the policy provision that governs the phrase authorized and the statute that we think governs the phrase subject to reimbursement and paid for is that the court, as I mentioned, did take evidence of parole evidence and asked because he was curious, well, what were the parties' intents, what was the intention of the parties as they entered into this policy. And of course, the parties were the Kansas High School Athletics and Activities Association and Mutual of Omaha. And there was a specific provision and a specific warning that the Activities Association sent to the school districts that said, be warned, the coverage has changed. We've changed from a different insurer. We have a new policy, and the new policy does not cover volunteer travel.
Now,
Just mention-
are you saying that we're bound by that interpretation?
Clearly, you are not bound by that
Or
interpretation.
neither was the district court?
That is true to the extent that the words of the policy are unambiguous, which we of course think they are. We think they're unambiguous our way. The other side thinks they're unambiguous their way. If there's an ambiguity, the district court settled the ambiguity in our favor. And you're not bound by that determination, obviously, but you would be bound to give it some discretion as a fact-finding determination of the district court if you get to the issue of parole evidence. That's all I have, Your Honors.
I have one question. If an adult would have been in this vehicle, whether an adult was there or not, the cost to transport this child would be the same, is that correct?
That is true.
And if an adult would have been driving this vehicle, it would have been subject to reimbursement under your argument of the policy.
Arguably, it could have been subject to reimbursement, yes, depending on some of the other factors, but yes, it would certainly be a lot closer call. And, but presumably, the safety factors and from the insurance company's standpoint, the requirement of school permission and subject to reimbursement comes with protections like this, one afforded by state law, that an adult be present. And presumably, not necessarily, but presumably with the presence of an adult, some of the fairly significant safety factors attendant to this travel would not have also been present. The adult would have provided a supervisory role. At least that's conceptually.
So I guess my next question follows, what was the purpose of the permission form for the parents to sign that the school wanted for the kids to be transported by other kids?
There wasn't evidence given on that point or elicited on that point. The coach didn't testify. So I would be speculating to tell you that I knew what the purpose of the form was other than reading the form. But it says,
It speaks for itself, then, is what you're...
it's the best I can do for you. It says that it is a release and it grants permission, not from the school, but from the parents for different types of travel and for both the games and the practices. So presumably it was to cover the practices. There was a bus for the games, and the permission slip, the note says that. There will be a bus available for the matches, but the rest of our transportation needs are I think it says, given to particular or unusual circumstances, something like that.
Thank you.
Thank you, Your Honors.
Thank you, counsel.
Counsel, before you start your rebuttal, there was some testimony during the trial from an official, Mr. Petz, saying there's no way that the school district would knowingly allow or even using hear a word authorize, students to get in the back of a pickup truck to go to an event. I wasn't clear. Is that what happened?
That's exactly what happened.
Well, doesn't that perhaps show why we have these restrictions? Because we all know it's a very bad idea to transport people like this in a pickup truck. And this is something that the school would want to have control of, and which, under your interpretation, I don't think they would.
Well, and it's, as a practical matter, it's difficult to know how much you can control. In this particular case, it happened, but the school guard opened the gate and allowed the driver of this vehicle to leave the school parking lot with the kids in the back and said,
Wished them good luck at the game, right?
and wished them good luck at the game, precisely. The fact is that the policy terms are ambiguous, at least His Honor, learned Judge Lamson so found that there's ambiguity, and if they're unambiguous, we probably would not even be here arguing about it. And the reason we're here is because they elected not to define what these terms meant, not only authorized, but
Well, do you agree with me if they would have said authorized by law?
That's all it.
That would have been end of story?
Then, no, because then we would have the second question of whether or not the law authorized it, and we believe it does. Clearly, 728305 deals with one thing only, buses, bus transportation. There's no Kansas statute that I found that specifically excludes all modes of transportation with an adult not present. And 8301, which addresses the question of furnishing and providing transportation, specifically authorizes reimbursement for transportation such as was done here, and does not make any reference to an adult accompanying these students. Thank you very much.
Counsel, before you sit down, had this young person been 21 years of age that was driving Jesus in the rear, would his transportation been subject to reimbursement?
Absolutely, it would have been subject to reimbursement.
If he's under 21, he's 18 to 21, he's a licensed driver, would have been subject to reimbursement?
Just as well, because the terms of the policy, again, refer to individual travel. It's very clear. They intended for individual travel to be covered in this case. We didn't elect to use that term, they did.
Thank you, counsel.
Thank you.
Interesting case. We will take that under advisement and issue our opinion in due course. Thank you. Next matter is 108-706, FV1 Incorporated in trust for Morgan Stanley Mortgage Capital Holdings versus Constance M. Kolovig and others. This is a civil case that raises the issue of splitting a mortgage and its promissory note. A junior lien holder, Bank of the Prairie, claims that its lien is superior because the original lien holder, GMAC Bank, split the mortgage and its promissory note, thereby losing its right to enforcement. The district court granted Bank of the Prairie's motion for summary judgment based on this theory, and FV1 appeals. All right, counsel.
Morning, may it please the court.
Counsel, I would say that,
Let her get her appearances in first. I need her appearance.
Stephanie Mendenhall for, it's FBI. There has been some confusion at the district court.
FBI?
And the appeal, whether that's a little one or a capital I. So,
Okay, thank you very much. And do you want time for rebuttal?
yes, 3 minutes, please.
3 minutes, you've got it. Go ahead.
Counsel, Justice Johnson of the Supreme Court's father once used to say, if you're not careful, you can learn something new every day. And I would say that I did learn something new. I had never heard of the word allonge before.
Elonge.
A-L-L-O-N-G-E. So you've contributed to the education of the court and a few other judges on our court, as I might add.
I think that's great.
Thank you very much.
As the court has stated, this is a foreclosure action where the key issue is whether a note and mortgage are split. The facts are fairly typical, and they were uncontroverted at the district court level. This court has recently issued 3 comprehensive decisions on the splitting issue. U.S. Bank versus Howie last June, MetLife Home Loans versus Hansen last September, and just recently on March 8th, Bank of America versus Enda. And it is FVI's position that those cases are controlling and should be applied here to reverse the district court and find that FVI's note and mortgage are not split. The basic facts are that FV1 is enforcing a note and mortgage. Sorry, FBI. See, I do it too. Bank of the Prairie has junior liens and filed a summary judgment on the sole issue of whether FVI's liens were split, because if they are, that would make Bank of the Prairie first. And the court did grant the summary judgment on Bank of the Prairie's position. The facts were not in dispute, so the issue for the district court was one of law and applying the law to those uncontroverted facts. And what I'd focus on this morning are the errors by the district court, the most the largest error being finding the split based on a mischaracterization or a misinterpretation of the facts. The district court found that the note and the mortgage were split not at their origination, which is a common fact pattern, but because the note was endorsed down and transferred by GMAC Bank. But then the district court said GMAC Bank retained its interest in the mortgage until an assignment 2 years later. And that is not factually accurate. What actually happens in this case, as in Hansen, for instance, and Howie, is that it's a MERS mortgage, and MERS retains the interest, the title interest in the mortgage. So while the note is being transferred down, MERS holds the mortgage and then eventually assigns it.
To me, MERS is a phantom. It's this electronic creature that I suppose if you poked it, it wouldn't bleed or bruise. And so you're saying when this was assigned to them, they also acquired the mortgage rights as well?
When you say them, do you mean MERS?
Yes.
MERS is named as the nominee in the mortgage, which gives them a title interest. As this court has held in Hansen, the beneficial interest in the note and the mortgage transfer together with the note. Then
Unless
MERS
they're
holds the
split.
title interest.
Unless they're split, but there has to be some sort of unequivocal expression of splitting, doesn't there?
Correct. And that is another point of error for this district court, is that it held that there was an agreement to split that is simply not reflected in the evidence.
How do you find that in a motion for summary judgment? I mean, what is in the findings of fact that would demonstrate that unequivocal splitting?
The general rule that the mortgage and note stay together comes from the restatement.
Correct.
And the restatement gives some clear examples of when there may be an agreement to split. And I think if there were such an agreement, that would be in a statement of fact, such as we are assigning you this note, but we are not assigning you the mortgage. And that's
Typically,
in
how is that
writing.
done? Is that done on the endorsement, or is it done on a élanger?
It could be either. The examples given in the restatement, it's a written assignment. So for instance, our assignment of mortgage could say, I hereby assign you the mortgage, but specifically reserve the note for myself. It has to be some express intent to divide the two. And the reinstatement and the Kansas laws are clear that absent something express, that the two should go together.
It seems to me that the market has dramatically changed the way we view such things, because the bundling of negotiable instruments and selling them wholesale, and then the mortgage kind of trailing along behind them down the path, this electronic path of recordation eventually, that is dramatically different than way back when I was doing notes and mortgages.
Yes, it is different, and it has to be analyzed a little more deeply, but the end result is the same. And this court has held again in those decisions, especially Hansen and Howie, that the note can transfer down, the mortgage can stay with MERS, and as long as there's not an express intent to split and the agency relationship is there, that they're not split. There's also, as this court said in Hansen, the concepts that mortgage follow note and note follow mortgage. In this case, if the district court found that the transfer of the note was unclear or we weren't sure when it happened, because as is common, the endorsements aren't dated, we have a clearly dated assignment, June 15, 2011, which was before the foreclosure case, and under this court's interpretation of the laws and Kansas statute, that note would go with that mortgage. So at the very least, we know that they were traveling together on June 15, 2011, prior to this case being filed.
What relief are you asking?
At this point, we would ask that the district court summary judgment order be reversed. After entry of summary judgment, the court entered a separate default judgment granting the actual foreclosure because the borrower did not appear in this case. So we would ask that both of those, to the extent they granted judgment to Bank of the Prairie, be reversed, and that this court find that FVI's note and mortgage are not split. This court has de novo review over that issue, find that they are not split and that FVI has the authority to enforce those. I think then a remand is likely required because FVI at this point in the district case had not sought its own judgment.
What is the reason for shifting, I don't want to say split, but shifting part of the note and mortgage over to MERS?
It's strictly a title interest.
Yeah, but why do they do it?
I think for ease, for convenience, this court has analyzed the MERS system pretty thoroughly in its recent opinions. Prior to the MERS system, you had to do an assignment every time it changed, it moved, and as the judges pointed out, that happens so much more frequently now. MERS was designed as kind of a one-stop shop so that you don't have to mess with the mortgage every time you're moving the note.
Right, so it wasn't established in order to split the two.
Certainly not, and that's why we've argued and the court has held that beneficial interest, your right to enforce the two, go together, and it's just that title interest that stays with MERS until MERS assigns it out.
Thank you.
So what fact did the district court miss in granting summary judgment?
I think it's threefold, actually. The first fact is just the existence of MERS. The court interpreted GMAC Bank, the original lender, to keep the note and mortgage. And so when it moved the note, the court said that was a split. But what was actually over here was MERS. And so there's no split because of the use of MERS. So the court missed that fact. The court also neglected to apply Howie, which we think would have been dispositive. The court found this express agreement to split, which was not based on any evidence in the record. And then the court ignored the assignment having been executed prior to the filing of the foreclosure suit. And the court said there was no evidence that FVI had the note and mortgage at the time the case was filed, when in actuality, based on that assignment, that is the evidence.
Now, was that the blank assignment that you're referring to?
The assignment of the mortgage by MERS, not the blank endorsement.
But I'm talking about the note. Are you talking about the blank endorsement of the
No.
note?
No, I was speaking of the assignment of mortgage. It was done prior to the lawsuit being filed. Is there more time?
You've got 2 minutes.
Okay, great. What FBI really wants this court to look at is that the facts of this case are the same as Hansen. Now, our district court didn't have the benefit of Hansen because it was decided later. But we have undated endorsements of the note, which is common. The final endorsement is in blank. We have an assignment of the mortgage from MERS directly to FBI. We have a borrower in default who did not appear in the action, and we have the beneficial interest in the note and mortgage with the title interest in the mortgage all being held by FVI. So the instruments are not split. FVI has standing to enforce those instruments, and that's why we would ask that the district court be reversed.
Thank you, counsel.
Morning.
Morning, counsel.
Please the court. Tim Gerard appears on behalf of Bank of the Prairie, appellee in the case.
Is it Calavig?
Calavig is my
Calavig,
understanding of the pronunciation.
they kind of threw up their hands and didn't appear, right?
A defendant in a foreclosure case that for all intents and purposes has been foreclosed. I, by the way, will likely refer to FEI as FV1. This case was filed on June 24, 2011, and I've been calling it FV1 for a considerable amount of time, so excuse me if I do that. I'm going to dive right in. I do think that there are multiple issues in this case. It's not just an issue of split of the mortgage from the note. There's also issues with regard to the transfer of the promissory note that FEI seeks to enforce and whether or not they ever proved that they had enforcement rights in that promissory note. And then, of course, there are issues of standing. But I'll start right in with the court's questions about proof of this split, because obviously what has happened here is that the trial court granted Bank of the Prairie's motion for summary judgment, giving this court the task of determining whether reasonable minds could differ on the conclusions drawn by the trial court based on the evidence put in front of the trial court. I hate to stand here and engage in the non-glamorous process of discussing facts, and I did hear Your Honor's admonishment earlier about not dwelling too much on that, but this is a fact-driven case in our view. And it's not only that the facts are important, it's the how and when did the facts come into play that make it.
There's no disagreement about the facts, or there shouldn't be too much in a summary judgment case. If summary judgment is granted, there should be some undisputed findings of fact by the trial court, correct?
Indeed, and there were, and in fact, the court, as it was obligated to do, indicated that it viewed the facts most favorably for FEI in reaching its decision. It did that, fulfilled that obligation. It's really the argument of what the facts say that comes into play here. And again, the how and when is important because what we basically have is FEI giving the court a handful of different snapshots about its positions. Those different fact snapshots varied and were contradictory at different times. And it's review of the facts that helps one understand not only what the facts were in front of the trial court, but what facts were believable or what facts weren't believable.
Counsel, did you have?
Well, surely you're not saying that the district court weighed evidence at a hearing on summary judgment, are you?
I believe that the district court did take into account evidence.
You're not supposed to do that, are you? Weigh evidence at a motion for summary judgment?
I think the court has to make some determination as to whether the evidence or information that's presented is admissible evidence for purposes of granting or denying a motion for summary judgment.
Counsel, I know this question is not really dispositive of too much, but what would be the purpose of splitting the note and the mortgage? Why would they do that? It seems to be more reasonable if I would follow counsel for the appellant's reasoning and say, well, you know, things have changed and you don't want to split them off, but by using this process, you can save yourself a lot of time and effort. So why would they want to split it?
I don't know that I can answer that question with a specific answer because I don't know why they would want to split it necessarily. What I do know.
Well, I can't see it either, which is, you know, kind of sets off, you know, fireworks, waves red flags, things like that, that surely they didn't do it just for the heck of it. They say, well, this is going to not help us in any way and it's going to hurt us in some way, but so let's just go ahead and do it anyway.
Yeah, I understand, and I also understand that Kansas law generally supports the notion that notes and mortgages travel together absent an agreement to the contrary. And
And
that,
there's a good reason for that. I
and they're
mean,
good-
that traditionally in common law, that's your only security on that note is that mortgage, right?
that's right. And I think in recognition that there are good reasons for that, the court or the law kind of acknowledges the passing. And on the other hand, the law acknowledges that there are instances in which promissory notes and mortgages are split. And whether or not that's a good idea or I can give you a good reason that that might occur isn't the issue so much as that sometimes, in some cases, promissory notes and mortgages apparently are split because law exists that indicates that splits of notes and mortgages is recognizable in Kansas.
Well, there are market forces at work nowadays where bundling of negotiable instruments and payment of enough money, people sometimes don't care about that interest, that mortgage interest, and it trails behind somewhere along the path. But the big problem here is, for you, isn't it, is MERS?
I would say, well, by the way, thank you for articulating the point that it does happen probably in light of today's market that notes get passed and mortgages don't. But I don't know that MERS is an issue for us. In fact, MERS has not been an issue in the case. MERS, I think, to answer a question asked earlier, is MERS is basically an agent of the mortgage lender. So when we're talking about activity of MERS, we're really talking about the mortgagee under a mortgage. I think MERS exists so that there can be assignments of mortgages to MERS, or that MERS acts as nominee for lenders so that they don't have to spend a whole lot of money with regard to registering mortgages if mortgages get assigned. But that aside, because that really wasn't much of an issue in the case, the facts of this case indicate as follows. First of all, on the date the case was filed, June 24, 2011, FBI, the plaintiff in the case, attached a promissory note dated September 16, 2005, in which GMAC Bank was the lender. That note had been endorsed to, on its face, GMACB Asset Management Corp., and FE1 attached to the petition a mortgage in which the mortgage lender was GMAC Bank. So on the date the case is filed, FBI gives the court the first snapshot of the facts, which show the plaintiff is FEI, seeking to enforce a promissory note to GMACB that's been endorsed that way, and a mortgage in which the lender is GMAC Bank. Three different entities, no identity between them. The facts as they came out indicated that that endorsement from GMAC Bank to GMACB occurred on November 15th, 2008. Uncontroverted fact. There was no evidence in the case that the mortgage was assigned at that time, and in fact, the only evidence in the case that related to the mortgage was the June 15, 2011 assignment of mortgage, June 15th, 2011 assignment of mortgage, which, by the way, under the how and why the information came to the court, was presented to the court by FE1 in a motion to dismiss a counterclaim, the counterclaim filed by Bank of the Prairie. It's kind of a backwards foreclosure case, but in any event, on October 15th, nearly 4 months after the case is filed, the assignment of mortgage is brought into the case. It again being dated June 15th, 2011, and it indicates that GMAC Bank, through MERS, its nominee, has assigned the mortgage to FE1. So as of October 15th, we have a different snapshot now about GMAC, or FEI's position, given that at that time, it appeared to be seeking to enforce a promissory note that was payable to GMACB, but a mortgage that had been assigned to it on June 15th, 2011. The court found that that assignment of the mortgage at the later date was the evidence that there was an agreement, that when the note was transferred in November of 2008, the mortgage hadn't been transferred. And in fact, FBI argued in the case and in that motion to dismiss filed on October 15th that the mortgage had been assigned in 2011, June of 2011, because GMAC Bank authorized MERS to assign the mortgage, which occurred again in June of 2011. FBI also, through its counsel, argued at the motion for summary judgment hearing that it had showed the court why it was that the note was transferred in 2008, but that the mortgage wasn't assigned until 2011. And frankly, for FBI to come in later and say, well, we didn't assign the mortgage in 2011. We assigned it in 2008. Again, presents facts from one party that are inconsistent with facts they've previously provided the court, because at different times, what they again argued was that it was GMAC Bank that transferred the mortgage, not GMACB, not Ally Bank, not any of those other prospective people through whom they say they took the promissory note. This is not the Hansen case. In the Hansen case, and I know
I was
you're
just going to ask you, why wouldn't Hansen control? Because we've got people who, the Calavigs, thrown up their hands and they're gone, they haven't answered. Why doesn't Hansen control?
because in Hansen, the real issue was whether or not MetLife, and I know Your Honor was involved in drafting that opinion, but whether MetLife Homes had become entitled to enforce the mortgage. It was undisputed in that case that MetLife Homes had taken a proper assignment of the note or had enforceability rights in the note. It was, again, a matter of whether or not it had enforcement rights in the mortgage. In this case, the real issue is whether or not FEI had enforcement rights in the promissory note. And therefore, they're different. And in that regard, on the promissory note, just a quick recap of different snapshots. I've already talked about the snapshot given on the day the case was filed and the fact that there was an identity between any of the parties. On October 15th, we see October 15th, 2011, we learn that there was an assignment of the mortgage. On December 22nd, 2011, nearly 6 months after the case was filed, FEI produced for the first time the allonge, or the allonge. And this is, again, because we don't have any identity between the plaintiff in the case and the person to whom enforcement rights in the promissory note have been granted, which until December of 2011 looked to be GMACB, Asset Management Corp. So the allonge shows up. But the problem with the allonge when it showed up was that it wasn't attached to the promissory note. FEI could not explain when it was created, who had executed it, or on what date it was executed. And there were foundation and authentication issues with regard to the allonge. But in any event, they give us a little bit of a snapshot, maybe a fuzzy one at that point, again in December of 2011, only to be changed again in March of 2012, on March 26th, when a color copy note, that's what we referred to it as in the lower court, shows up. And that color copy note was a copy of the same note that had been attached to the petition, except that it had a couple of new endorsements on it, or different endorsements, that weren't on the copy attached to the petition. And in the color copy note, it appeared that FEI was arguing that, no, it wasn't through the allonge.
Well, how did the district court treat that?
We argued that neither the allonge nor the color copy note had been supported with authentication or foundation, shouldn't have been admissible in the proceeding for purposes of the courts determining which evidence to rely and ruling in the case. The court ultimately, without mentioning much, either of those, the allonge or the color copy note and the purported blank endorsement on that, effectively simply concluded that they hadn't proven their enforcement rights. FEI had not proven it as enforcement rights.
It didn't articulate that the court sustained your objection. Is there anything in the record that says, yes, I sustain your objection, these are not admitted?
No, there's not.
There's nothing, yeah.
There was discussion at the motion for summary judgment hearing in June.
It kind of gets fuzzy, doesn't it? The district court's opinion is kind of fuzzy, isn't
I
it?
take no pride in authorship, so I don't want to be too critical of a court's opinion. But having, again, been on the ground level with the court in terms of what evidence was presented or what evidence wasn't presented.
But we have to deal with that final order. I mean, we're confined to those findings of fact, are we not?
I agree.
I mean, all of this other is interesting, but we have to, this is all we can deal with. We can't go outside of what that court found at that point.
I agree.
Correct.
And yeah, and ultimately, if you look at those different snapshots that FEI provided about its position was varying. It was, they contradicted themselves from time to time. And the question became what was believable. And I don't think that the trial court could believe that these purported endorsements that came 6 months or 9 months after the case was filed without any explanation as to when they were created or who created them or whether the people that purportedly signed in those had any authority to sign an endorsement. I don't think the court relied on any of that information because the court couldn't reasonably do that.
Counsel, your time's expired. If you want to sum up, please feel free.
Actually, the summary in our position is simply this. We respectfully offer that reasonable minds could not have differed with the trial court's decision in light of the evidence, and in that regard, we would ask that the trial court's decision be sustained.
Thank you.
Thank you very much, Your Honors.
Counsel, you've got your 3 minutes.
Thank you. May it please the court. I don't think I'll take that long.
We will punish no one that uses less than their allotted time.
Thank you. I just want to focus in on a couple of things that Bank of the Prairie has argued. One is that it's a fact-driven case, which isn't entirely true because the facts were not controverted. All the facts that counsel has described with regards to the endorsements, the assignments, those were admitted by FBI because they were accurate recitations of the facts, and those were then adopted by the district court. The issue is how the district court applied the law to those facts. And so we have one set of facts. Bank of the Prairie says it results in splitting. FBI says that it doesn't.
Well, counsel has unequivocally denied your position, saying Hansen doesn't apply. You want to respond to that?
Our argument is that the facts are directly on point, down to the detail from undated endorsements to involvement of MERS, MERS holding the mortgage during those endorsements, and then an ultimate assignment of the mortgage from MERS to the plaintiff. The facts are the same. Bank of the Prairie said that MERS was not an issue in this case, and it's true that it wasn't challenged. As in Hansen, counsel is correct that the borrower and the junior lien holder were challenging the existence and involvement of MERS, and Bank of the Prairie here admitted that MERS was fine, the assignment for MERS was fine, and didn't challenge agency between MERS and FBI like happened in Hansen. But MERS is still an issue because where the district court here got to splitting was because it didn't account for MERS. It made a factual finding that MERS executed an assignment to FBI, but then in its legal conclusion said that GMAC Bank assigned the mortgage in 2011. So the district court acknowledged the assignment from MERS, but then incorrectly stated the assignment was actually from GMAC
Let me
Bank.
see if I get this straight. GMAC Bank assigns the mortgage to MERS. Nominee?
MERS is named in the actual mortgage as a nominee
As a nominee.
from origination.
So under our brave new world of Hansen, and I say that because Judge Perrin is here,
I'm listening carefully.
then that means, can MERS enforce this mortgage? Or just hold it and pass it on?
They simply hold the title interest so that while the note passes down from the original lender to successors and assigns, the language of the mortgage enables MERS to hold that title interest on behalf of the original lender and all the successors and assigns of the note.
My second question is, why did it take so long to get the color copy of the mortgage and the allongé to the district court?
That was not, the reasoning was not before the district court. It was simply a matter of me, and there was other counsel involved at the district court level, getting the original from the bank, which isn't always easy.
Flag control. All right, thank you, counsel.
I have nothing further at this
All
time.
right. Interesting, we will take that case under advisement as well. You okay? The next case on our docket is State versus Deshaun J. Butler. It originates here in Johnson County. In this case, a jury convicted Butler of kidnapping, 2 counts of domestic battery, harassment by telephone, criminal damage to property, and 2 counts of intimidating a witness. Prior to sentencing, Butler filed a motion for a downward durational departure sentence from the sentencing guidelines. The district court denied the motion, and using his prior criminal history to place him in criminal history category C, sentenced Butler to 102 months in prison for kidnapping and 24 months in prison for the remaining counts, and Butler appeals. Good morning, counsel.
Good morning. May it please the court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant, Mr. Deshaun Butler. And if I may, Your Honor, I'd like to reserve 3 minutes.
3 minutes, and I know since we're recording this, you'll want to speak in. You're being soft-spoken for some reason this morning,
Right.
counsel. I know you're capable of doing louder than that.
I will do my best.
All right, thank you.
All right.
You said 3 minutes, correct?
Yes, Your Honor, thank you.
Go ahead.
And unless the court would prefer otherwise, I'd like to focus on issue 1 and submit the remaining issues on the brief.
Certainly.
The first issue was that the state violated Mr. Butler's right to a fair trial and committed reversible misconduct during the closing argument. The standard of review that this court uses in analyzing a claim of prosecutorial misconduct is that it's a 2-step analysis. First, this court must decide whether the comments were outside the wide latitude that a prosecutor is allowed in discussing the evidence. Second, the court decides whether those comments constituted plain error. Because the state did not brief the plain error analysis, I will confine my remarks to whether or not it was error in the first place. So the first part of the misconduct analysis, unless, of course, this court would like to discuss the harmless error portion of it.
Well, I think you can probably make a very strong argument that there was error here in what the state said. He said that the statement by the defendant was not in the record, and it was in the record.
I'm sorry, it wasn't in the record?
It said it wasn't in the record,
Right.
and in fact, it was in the record.
Well, the prosecutor used a very specific quote in describing the testimony of the victim. And that specific quote was not in the record, and it wasn't even similar to what she testified to. And the exact testimony was in my brief in terms of what she said and what the prosecutor said in closing arguments. This is the last thing that the jury hears, and so it may have.
Well, you can raise the issue without an objection, contemporaneous objection.
Yes, absolutely. But as I was going towards that, it's the last thing that the jury hears, and so they may have been like, well, I don't think I remember them saying that, but if that's what she says, then I guess that's right. But very specifically, the victim said when she was in the car, she opened the door, and Mr. Butler came running towards the door and asked her what she was doing, and she told him what she was doing. The victim never said that Mr. Butler said, "Who told you you could open that door?" which is a much more threatening comment than asking her why she opened the door, or what she was doing, rather. So it's a fundamental rule of closing arguments that the prosecutor must confine his or her comments to matters in evidence, and this was not a matter in evidence, this particular quote. And it was a very specific quote. And I have my theories as to why the prosecutor may have made that mistake, but that's neither here nor there. That particular quote was not in the testimony, and therefore that is error.
But wasn't that one comment among many facts involving the allegation of kidnapping?
I would, yes, there were many other allegations in terms of what the state was trying to present as kidnapping. But I would say that that was the strongest part of the state's case. and the defense weakened the remaining portions of the case by pointing out that she was never dragged anywhere or taken by force in terms of how she was transported from area to area. And that, I think, goes towards the plain error analysis.
Counsel, what is our standard in reviewing such an error?
That's a two-part analysis. Let me see. First, you must decide if this is within the wide latitude allowed a prosecutor. And I would argue that stating facts not in evidence is outside of the wide latitude allowed a prosecutor. And secondly, you must decide if it constituted plain error and whether the statements prejudiced the jury against the defendant and denied him a fair trial.
And that's the one that I think you have to concentrate in convincing us.
Okay.
Do we have to be convinced that the outcome of this trial was changed because of this misquotation of the victim by the prosecutor?
Must you be convinced? Is that what you're asking me?
Yes,
Well, first of all, I'd like to just say, and I hope Mr. Obermeyer doesn't hold this against me, but the fact that they did not argue that it was harmless error, I believe the state has waived that portion of their argument. But,
Well, I think you're free to argue that.
okay.
Because we'll be asking him why he didn't refer to it in his brief.
Right.
But you're free to argue that.
Well, the second portion of the analysis, you must consider three factors in determining whether or not it constituted plain error. Whether it was gross and flagrant, whether it showed ill will on the prosecutor's part, and whether, in the last portion, which I think you're directing me towards, whether it was no reasonable possibility that the error contributed to the verdict. That third portion, I would also argue that because the state benefited from this error, it is their duty to show, it's their burden to prove that it wasn't, it didn't impact the outcome of the trial beyond a reasonable doubt. But I would say that Mr. Butler and his attorney weakened the state's case by the cross-examination of the victim and pointing out that she did not, she was not taken from place to place by, the exact quotes, I apologize. Basically that she felt like she didn't have any other choice but to go with him, but that she admitted she wasn't grabbed, dragged, threatened, all of those. She was able to fix her hair and change her clothes. She was left alone several times and never tried to escape, even though she claimed that she felt like she had no choice. Witnesses to the events just, never testified that he forced her to do anything or threatened her in their presence, but rather she was given opportunities to leave. And so there's overwhelming evidence that this was a bad night between the two of them, that they were fighting and whatnot. But whether or not that evidence, even viewed in the light most favorable to the prosecution, whether or not that amounts to kidnapping, Mr. Butler would argue that it did not. And that particular quote that says, a very threatening quote, "Who told you could open that door?" definitely swayed the jury in the prosecution's favor. There were several other issues. I'm happy to submit those on the brief.
I guess you don't think that that was a fair comment on the fact that she opened the door and immediately he was on her as to why the door was being opened?
She said that he asked her what she was doing, and I told him what I was doing, opening the door to get air. That doesn't, to me, that is not in the same tone even as who told you could open that door.
But in the context that she was under his control, do you not think that that was a fair comment by the prosecutor?
I do not. I think that went way above the tone of what her testimony was.
Wasn't the evidence that he told her to stay in the car? She could not leave the car?
I don't have that particular portion of the transcript with, I mean, it's over there, I can look that up and get back to you on rebuttal, but that very specific and threatening quote, I think, went above what was testified to.
Joe, any questions? All right, thank you, counsel.
Thank you.
Like I say, we will not punish anybody for taking less than their allotted time.
May it please the court, the state of Kansas appears by Stephen Obermeyer. I wanted to talk about the first issue and the fourth issue if we have time. But as to the first issue, there was testimony that the victim was in the car following a night of being taken from apartment, having to duck down when the police are shining their lights in her apartment, taken to 2 or 3 different places. And then when she tries to get out of the car, the defendant comes up to her and tells her something which prevents her from getting out of the car and preventing her from trying to escape.
Well, it wasn't her testimony at that time, if I recall correctly, that she was trying to escape. She wanted to open the door because it was hot and get some air.
Well, yes, at that point, because she knew that she was in an unfamiliar area and did not want to try to escape there. So yeah, she's opening the door, and then the defendant is right there asking her.
But you admit there's a misquotation here. There's nothing there's no, why did you open the door, or who told you could open that door, that can be found in the record. It was a misquotation.
Those exact words were not used as far as the victim's testimony at the trial.
Now, if we say the rule is prosecutors should not misquote witnesses, which I think is a very good rule, the question then becomes, in this particular case, is that harmless error?
Well,
Doesn't it?
yes, I don't think it is error that the prosecutor could say that he asked her what she thought she was doing, or why did you open the door, or things like that. And you can't tell from the transcript what the tone was in the closing argument when this is said. But this was a 3-day trial. Actually, it was a 4-day trial. The closing arguments were given on November the 10th. The jury was instructed that statements of counsel are not evidence. If anything is presented that's not evidence, any statements presented that are not evidence, they should be disregarded.
And there was no contemporaneous objection.
There was not, but it's not required for this issue to be raised, but it's indicative of the fact that if the defense counsel or the judge thought there was a flagrant issue, they could have objected, and they did not at that point. That's correct. So closings are on the 10th. November 11th is Veterans Day. So the jury goes home for a day and comes back on November the 12th to continue to, I think, commence deliberations. The jury has asked for a couple of readbacks, including a readback of the victim's testimony. The jury has several questions asking if it can look at transcripts and let's see, transcripts, readbacks, and then the jury finally comes back on that same day, the 12th.
Any evidence of ill will here on the part of the prosecutor?
No, I don't think there's evidence of.
I mean, certainly in the cases where we have found ill will, I mean, the record in those cases clearly demonstrate from the words that are used and the language and even the comments from the judges on the tone of voice used, that is ill will. But anything like that here?
No. And the lead case on ill will is State versus Pabst, and the prosecutor called the defendant a liar 11 times and tells the jury, I look into your eyes and tell you he's a liar. We have one reference to this statement, and by the time you get to trial, you've had a preliminary hearing, you've had meetings with victims. That was probably told to the prosecutor. It wasn't on the stand, but there's not evidence of ill will as far as that.
And this was from the prosecutor's rebuttal?
I'm not sure about that, Judge Perry.
Okay, well, that would seem to make a little bit of difference, because if she had said it on the first, then there would have been an opportunity to reply. Whereas if it was during the prosecutor's rebuttal, there would be no opportunity to reply.
That's correct. I think, well, I'm not sure as far as where the context was on that.
How far does the prosecutor's right to make fair comment on the evidence go in this situation?
Well, I know you can't go so far as to kind of create a storyline of what
You
the.
can't call him a liar.
Correct. You cannot do that. I'm not sure as far as, yeah, I know there are several cases on words you can't use, and liar's a big one, but I think in this case, just stating that, making that statement, stopping her from opening the door, asking about opening the door, did not change the jury's mind. In fact, the jury found the defendant guilty of a rape count and unlawful criminal deprivation of property count, so.
Not guilty.
Correct, not guilty. I'm sorry. If I said guilty, I meant not guilty. He was found guilty of the kidnapping, which is a taking or confining. There was plenty of evidence of her being taken around the area that night, as well as confined. And I think you can convey that he said something to her after she opened the door. And so I think.
Counsel, you wanted to speak to issue 4, and that is of particular interest to me as well. And if I recall correctly, that's on the denial of new counsel.
Correct.
What were you wanting to argue?
I wanted to argue that this issue arose on the morning of jury trial when the jurors are waiting to be seated, and the experienced attorney, the court was earlier talking about bar numbers, Mr. Edmonds was the second attorney appointed to represent Butler. Judge Welch told Butler that he's practiced law for over 20 years. If his ideas disagree with yours, they're the ones that are going to win out because he's a lawyer. And Mr. Edmonds and I had actually gone to law school together, and his bar number is 12564. So he'd been doing that for a long time. He brought the issue to the court's attention that he wasn't satisfied with what Mr. Edmonds had been doing. Judge Welch inquired about what's the reason for this, and it was not a justifiable dissatisfaction with appointed counsel as far as.
What's our standard of review of such a question?
The standard of appellate review is whether or not there was an abuse of discretion in determining that. And typically, abuse of discretion is usually whether no reasonable person would agree with the position taken by the district court. In this case, the district court followed the law, so there's no allegation that she disregarded the rules. It's a judgment call, and a reasonable person would agree with the district court in denying the motion to appoint new counsel. And so I think Judge Welch did explore the issue, because it's error if you don't explore the issue, and she determined that there was not an irreconcilable conflict or complete breakdown in communications. And again, in fact, the attorney that the defendant had obtained at least a couple of acquittals on a several count case, so I think he was well represented. But there was no abuse of discretion on that request made on the morning of trial. Unless the court has any other questions.
Thank you, counsel.
I ask you to affirm.
I don't recall the defendant or his counsel saying that their relationship was damaged to the point that it could not continue.
Correct.
Is my recollection correct?
Your recollection is correct. The defendant was dissatisfied that his attorney had not visited him as often as he wanted to visit him. There might have been some tactical issues as far as witnesses that had been discussed, and Judge Welch said that I haven't heard anything that would make me think that there's this conflict, so.
Well, there's no obligation for counsel to visit a defendant as often as he or she would desire. Is that correct?
That's correct.
That's the professional discretion that we leave with lawyers.
I think so, especially when you have a micromanager like Mr. Butler, where you saw what he did on the night of the offense. So he likes people under his thumb, and the attorney doesn't have to come over and visit him as often as he wants. And Judge Welch said attorneys can do a lot of things on the case when they're not visiting with you, research, listening to recordings, what witnesses to call, but they're not the decisions of the client, they're the decisions of the attorney. So that's why I argued that that was not an abuse of discretion.
Thank you, counsel.
Thank you.
Normally, I waive rebuttal, but I would like to discuss a few things. And-
Certainly, since we brought up an issue that you didn't.
Yes, absolutely, and I will get to that in just a moment. Just in discussing the factual scenario about being in the car and whether or not she was told that she couldn't leave, I didn't find anywhere in the record, especially right before that testimony, where she was told that she couldn't get out, just that they had stopped at a couple different houses. She didn't know the area, so she thought if she got out, she didn't know who he knew in the area who would stop her, kind of thing. But whether or not she was specifically told not to leave or that she couldn't get out of the car was not in the testimony. And addressing issue 4, or the issue that Mr. Obermeyer addressed, I'm not sure if that's issue 4, but
I think it is. It's the new.
The new
wanting
issue.
a new lawyer.
yes, a new lawyer. I have a problem with the particular timing of the discussion with the judge. First of all, Mr. Butler doesn't have to only show that there was the conflict between the two was, let me get to that portion of it so I can discuss it. Justifiable dissatisfaction can also be from a conflict of interest, not just irreconcilable conflict. And Mr. Butler, he spoke to the judge asked some questions, then he said, we have a conflict of interest. I believe that he doesn't have my interests at heart, but he specifically said, I have a conflict of interest. And at that point, the judge did not inquire further. And at that point, I believe she abused her discretion because a district court does abuse its discretion when they are notified of a potential conflict of interest and they do not inquire further. And that comes from several of the cases that I cited in my brief.
What was the conflict?
Well, I guess we won't know because she didn't specifically ask him about that. She just goes off on her ruling of that he is an experienced attorney and what obligations he has as an attorney versus what the defendant can do.
Well, there was apparently some statements by him that the conflict was that he couldn't control all aspects of his defense. And as we all know, the defendant only has a few things that they specifically can control. I think one is whether they plead guilty or not, whether they take the insanity defense, whether they take the stand or not. There may be something else, but the conflict that they spoke of was that the lawyer wouldn't take orders, and I think our law is that except on those very limited exceptions, the lawyer does have the authority to control the defense.
I would argue, and that I agree with you on the law there. The specific facts of this particular interaction between the judge and Mr. Butler was that he did complain about not being consulted on certain issues and whatnot. After all of that, he says, I think we have a conflict of interest. And at that point, the judge does not ask what he thinks that conflict of interest is. And then I would argue that that was not fully inquiring into his potential conflict. And so that conflict of interest could have been something different than what he had alleged earlier in the complaint.
But other than what we've just discussed, he never told her that
I don't believe he was
had any
given-
other kind of conflict with him.
I don't believe he was given another opportunity to discuss that. The judge did erroneously believe that his previous attorney had been discharged because of dissatisfaction with that, but he actually had a conflict of interest in terms of the witnesses that were being called, and he could not represent the defendant at that point. So I think she held that against him in terms of him wanting a new attorney now, a second attorney, but that was not the situation. And so I don't know how much that played into her ruling, but I think she was maybe perhaps annoyed with him because of that. And so she didn't properly inquire into the conflict of interest, the potential conflict of interest that we don't know what that is because he was not given an opportunity to discuss it. I hope I'm talking loud enough.
Yeah.
Thank you.
Thank you, counsel.
All right. And unless you have any other questions, I submit the
Well,
remaining.
wasn't the timing of his request the day of trial?
It was the day of trial.
I know,
and
but wasn't that kind of an unusual timing for this request?
I don't know if he was given another opportunity beyond that in terms of any other hearings that were given. And if that, he was maybe just alerted to that conflict of interest potentially. I'm not sure because that's not in the record anywhere. But yes, I could see why the judge would tend to want to rule against him in that and maybe not fully inquire. But I would argue that she abused her discretion in not fully inquiring.
Thank you, counsel.
Thank you.
We'll take the case under advisement and issue an opinion in due course. All right, we doing okay? Our final case this morning is State of Kansas versus Amy Lynn Crutchfield, number 106541. Police saw Crutchfield leave her Overland Park hotel room and enter a vehicle with an improper tag. She consented to a search of the vehicle, which yielded evidence of identity fraud. Police ended up arresting her boyfriend, searching her hotel room, and finding a meth lab inside. She was convicted of manufacture of methamphetamine, possession of some precursor drugs, and 15 counts of identity fraud, and was later sentenced to 60 months probation with an underlying controlling sentence of 138 months imprisonment, according to the synopsis.
Good morning. May it please the court. Carol Longenecker-Schmidt of the Appellate Defender Office representing Ms. Crutchfield. If I may, I would like to reserve 3 minutes for rebuttal.
You certainly may.
Counsel, of course, we have in this case the matter of the defendant's co-defendant, Mr. Tush, or Tush, however that's pronounced. I can see a lot of the arguments that you might make as explicated in your brief. A big problem I have with your client's position is the fact that at some point noon or something, the rent on this room expired, and the police asked the owner for permission then to check the room. The owner gave it, and that's when they legally, we might argue, found the evidence involved here. That matter, of course, was appealed and was decided contrary to Mr. Tush's desires. And as far as I can tell, it's the precise same legal issue. So how would you handle my difficulty with what I think is a very important argument here?
I think I would say that, or I would probably echo a lot of what is written in the dissent of that opinion. That is, dissent mostly focuses on the issue of attenuation and whether the hotel manager's consent was attenuated from the illegal police conduct. And I would argue that it was not, that there was only evidence that officers went and sought consent in order to search the room for a meth lab. I didn't find it, upon reading through the record, any evidence that specifically that they went and sought consent to look for evidence of forgery or false identifications or false checks, that sort of thing.
Counsel, I've got two questions for you along this line. First of all, are we bound by another panels of this court's ruling?
I do not believe you are.
And secondly, are the issues identically the same concerning the search?
They're not, I think they're close but not quite identical.
clarify for me how you think it's different in this particular case.
My understanding is, the way I raised this issue, I backed up the chain of events argument to start with when the officers knocked on the door and demanded that the door be opened with the seizure of Mr. Tush. That's how I pronounce his name. And I believe Mr. Tush started with the hand on the door as an unlawful search of the hotel room. So I'm backing up the chain of events a little bit. Ultimately, I'm not sure if that makes that big of a difference, because even if you don't believe the chain of events theory, if you believe that was halted or broken by the battery, you can start with the protective sweep or the warrantless entry after Mr. Tush was arrested.
Well, the protective sweep is basically when this search started, correct? I mean, if I understand the facts correctly.
Sure.
The man came to the door, Tush came to the door, peeked out, stepped out, tried to close the door behind him. Officer prevented that. Mr. Tush made a mistake and tried to put his hands on the police officer's person and then fell to the ground and was cuffed as a result of such an action. And then another police officer went in and did this protective sweep to see if there was anybody else in there, supposedly. There wasn't anybody else, and then, of course, discovered what was discovered by a more thorough search that was conducted later, correct?
Yes, that's correct. And I think two different officers provided two different reasons for that protective sweep. One was checking for other armed suspects, and the other was potentially destruction of evidence.
And this is before the witching hour, which is 12 o'clock.
Yes.
Noon. And because at noon, the room returns to the motel owner.
That is correct. And sorry, go ahead.
Your client rented this motel room, albeit under a false identity.
Correct.
So I suppose if there is an expectation of privacy, I hadn't thought along this line, I guess she's the one with the expectation of privacy in the motel room, even though she used a false identity to secure the room.
That's correct, and that could be maybe that's what you were going for, another distinguishing point between
Precisely.
Tush's appeal and this appeal.
She had rented the room, he
Sure.
did not.
That is correct, under another name. And I believe the testimony was that she actually only rented it, or was renting it one day at a time, and would pay each day to
Well, and
stay.
she certainly had plenty of identities to do that with, didn't she?
That's 15 of them, I believe.
Yeah.
15?
14 or 15, that is correct.
Well, now, the attenuation problem, of course, is a big one here. The officers looked in. One or both of their reasons might have been appropriate under the case law that we have. Attenuation usually refers to a different situation than this. Usually, when we have attenuation, it's that, well, maybe the officer did something slightly perhaps inappropriate. Most common one, I think, is that they stop someone for a traffic problem and perhaps do something incorrect, but then walk away. And then later on come back and say, well, can I search? And they say yes. And then the question is, well, is the officer's break from that person an attenuation so that we don't have the fruit of the poisonous tree and that they're not making a search that's unlawful? I don't know that I've ever seen one like this, because it's almost an inevitable discovery type of question here, isn't it?
Yes, and that's actually how I briefed it. That was my approach. I think that's how it was probably addressed in the district court, too.
Yeah.
This motel room isn't like a car. It's not going to leave.
Correct.
Once they had this man cuffed, and she was already under arrest, they had total access to this room. They had total control of it. Nobody was going to go into that room or out of that room other than was permitted by the officers, correct?
Yeah, that's my understanding. I think some family members showed up after both Ms. Crutchfield and Mr. Tush were arrested.
And
Tried.
they were not allowed entry in there. So is it unreasonable for the officers to wait 15 or 20 minutes to allow the witching hour to come up noon and then have Mr. Patel say, okay, go in and search how you went? I mean, is that unreasonable?
I think I hadn't thought of the question in terms of whether or not that was unreasonable.
That's why you've got a court of appeals.
Sure, to present those questions. I think my argument would be that if the illegal conduct hadn't occurred, if this chain of events hadn't been set in motion that resulted in Mr. Tush's arrest and that resulted in this protective sweep, there would have been no reason to search the room, because all they had at that point was evidence of the forgery and the false checks and the IDs in the car.
But they wouldn't need a reason, would they?
If they had consent
From
from the owner?
I suppose that is true, but here, the only reason why they sought consent was because of what they discovered in that room. There's no evidence on the record, there's no substantial competent evidence that the officers were going to go seek consent, ask for consent, based on the evidence of the crime they found in the Durango.
Once, you could equally argue that once they had control of the motel room, nobody was going to go in or go out, they could have gone and obtained a search warrant.
You could argue that. I would argue that, a search warrant for the
Motel room.
evidence. What were they looking for, though, is, I guess, my question.
The identity theft items and any other illegal activities. It was never clear to me from the record, when the officer did his protective sweep looking for people or weapons or whatever, did he detect an odor? Or was that in the record?
One of the officers said he took a few steps in the door and immediately smelled acetone, which indicated methamphetamine production to him.
So this magic hour that Judge Hill has referred to, was that an attenuating circumstance for the cop to keep possession of the defendant? So, I'm sorry, I'm speaking quietly. Was that a situation where the officer keeping possession of the defendant denied her the right to opportunity to re-rent the room to continue her control?
I believe I do argue that in the brief, because she was renting day by day, and so essentially the officers, through their illegal conduct, created this chain of events that prevented Ms. Crutchfield from re-renting the room.
Was there
or
any
from-
testimony to that effect, that she was going to do that?
I don't know that she stated on the record specifically, I plan to do this, but that's what she had been doing each day. And some family members had tried to do that, although factually it's unclear to me at what point.
Well, now that they'd been visited by the police, it would seem highly unlikely that she would keep her base of operations there, but, sorry.
There is one question that I want to ask before your time expires, and that is concerning the classification of the offense.
Yes.
What's your position on that?
Are we talking about the Snellings issue here? Or
The severity level of the crime?
Of manufacturing?
Yes. Isn't that an issue in this particular case?
I raised the issue of the severity level of possession of a precursor drug, and my position is that should be a severity level 4, I believe is what I stated.
Isn't that what did the district court do?
I believe they sentenced her as a severity level 2.
And your argument is clearly pseudoephedrine should be a severity level 4.
Right, because under the identical offenses doctrine, it's the same as possession of drug paraphernalia, I believe, with the intent to manufacture, and that is that statute includes a lesser penalty, and so Ms. Crutchfield should be resentenced as a severity level 4.
All right, thank you. Your
Thank
time,
you.
you still have your rebuttal time. Counsel, I'm going to jump before Judge Perrin asks you a question. I want you to address that last issue first, and that's the severity level of possession of pseudoephedrine. Is that a 4 or a 2?
I conceded at issue 1 that State versus Snelling's controls, and that is a severity level 4, so there should
So-
be a resentencing.
All right, it should be a vacation of the sentence and remanding for resentencing.
Yes.
All right, thank you.
With regard to the second issue in the brief, the first issue that was argued this morning, there was evidence that the defendant, Amy Crutchfield, had 15 false IDs. She rented the motel room in the name of Katie Courtney. One of the false IDs she did not have was probably Cinderella, which is what this case reminds me of, because at the magic hour, as the court referred to, that's at noon. It was midnight for Cinderella, but at the magic hour, her expectation of privacy evaporated, and she had no interest, no reasonable expectation of privacy in room 302. And I cited about 5 cases on page 21 of the blue brief that says once a hotel guest's rental period has expired, the guest does not have a reasonable expectation of privacy in the room.
My question is this, did I get the timing right? She's under arrest. Can they wait 20 minutes until the noon comes and then just ask for consent from the patel and he opens the door? Is that unreasonable? Is that something we should permit?
I don't think it's unreasonable, and I think it was permissible. The police knew she was not going to re-rent the room. She said as much. She was under arrest, so she wasn't going to be able to. The detective, the white-collar go-to detective, is called out to the scene. And usually you don't call out a detective, unless you're going to do something like a search warrant. And in fact, Officer Hampton testified that he was under the assumption that they were going to do a search warrant. So 12 o'clock comes and goes. Why get a search warrant when we can ask the hotel owner if they would consent to a search of the room? So I think the analysis could end at that it was reasonable, that there was no expectation of privacy that she had after 12 o'clock.
Now, we've got this other case from another panel
Yes.
dealing with Tush.
Yes,
And do you agree we're not bound by their decision?
correct.
And and is it the same? Is it really the same here?
Tush was an overnight guest. Well, the hotel didn't know he was an overnight guest. He wasn't on the register, but as an overnight guest under Minnesota versus Olson, I think he had standing. Yes,
Because he had expectation of privacy.
correct.
But his status under the law certainly changed when he pushed the officer, when he, I think, made a mistake and put his hands on the officer's person. Because every police officer I know, if you do that, something's going to happen, and it's usually you face down and end up in handcuffs.
Correct.
So once he changed, what's his expectation of privacy in that room? Because he's going somewhere else.
Correct. I think I guess a boyfriend's girlfriend's castle is his home. Home is his castle. But I think it's the same analysis, that as an overnight guest, he had an expectation of privacy or standing until noon, as did she, and she got arrested as well. So she wasn't going to. They were kind of similar in that regard.
Technically, she was under arrest first.
Correct. She was.
Out in the parking lot.
Yes. And he's not coming outside to see why, the very helpful boyfriend's.
He's not rescuing her, is he?
No, he's not, which added to the suspicion of the police as
No
far as.
Prince Charming here. another
No, he's not.
thing.
No, he's not. Thank you.
What time was she arrested? I mean, the record gives me the impression that she was out there more than just a few minutes. May have been an hour or so, but I don't know. Does the record, do you know how long she was in custody before they went to the door and knocked?
I don't know how, at what time the first officer comes out there to trigger all that.
Because he triggered this process by reading the tags.
Correct. And then she walks out of the hotel room and I did not include the time that initially happened. So I'm not sure. But I think at the point where you have the detective out there for the forgery unit, you had I think a KBI agent out there, and the issue of a search warrant just kind of went away when the room.
At high noon, it was done.
Right, at high noon, there was no longer an expectation of privacy, and the doors lock at noon, so the defendant or her boyfriend, Prince Charming, could not have gotten back in there without dealing with the hotel manager, who probably wasn't very happy that they'd rented a room under a false name in the first place.
Well, you're not arguing that she doesn't have an expectation of privacy because she used a false identity, are you?
No. But I'm saying that the touch panel, I don't think they needed to go through this analysis, but they got to the fact that, well, the police were asked for consent because they were also looking at this forgery issue. And, you know, I'm sure when the hotel found out that this room, that she's got 15 false IDs on her, rented in a false name, that the hotel manager's really not going to say, no, you can't search that hotel room. I don't think the hotel folks would have been happy with that. Regardless of the odor of acetone in the room, you still have the forgery evidence in the car, the MIP check, which is a payroll check, a software to make payroll checks. You can't print payroll checks in a car, as far as I know, and so I think it was reasonable for the police to want to look in the hotel room for evidence of that forgery and fraud that started in the car with a voluntary consent search. And again, Officer Hampton was under the assumption they were going to get search warrants for the Durango and the hotel room. I think that was all I had, unless the court had any questions. Again, I think my analysis is that the reasonable expectation of privacy ends, and the legal analysis can end at noon in this case. And I think Judge Bennett got it right in finding that there was no expectation of privacy at that time.
Thank you, counsel.
Thank you.
Unless your honors have questions, I will waive rebuttal.
Thank you, counsel.
Thank you.
Well, that concludes the oral arguments for this morning. As I stated previously when we started, we will certainly entertain questions from the audience at this time. Of course, I will tell you that we cannot discuss any of the cases that we've heard here this morning under our rules. Those, you'll have to wait for the opinions, just like the parties and the attorneys who argued the case, to find out what our rulings are on those. But is Ms. Tebby still here? Oh, there she is, back here. I think we can just be seated here. If anybody has a question, you know, raise your hand and.
I know many of these students, and they're very bright, and I'm sure they have questions.
Uh-oh. Now that sounded like a command. It didn't.
It's an encouragement to the students.
I see.
What that was.
Right here.
Question, and this is the second appellate court hearing that I've witnessed. The level of preparation for attorneys, how does that work in the scheme of things for how you're disposed, what you might hope for when people present to the court?
Well, oral argument is a key component, I think, in our decision-making process. It is the one time that we have that we can speak to an attorney about their case. Otherwise, we're forbidden by our rules of having what's known as ex parte communications. Now, if both sides are in front of us, I suppose we could engage in some sort of dialogue. But this is basically very important. They know their case because they've been dealing with it for a year or maybe longer in certain cases. The civil case, obviously, that we had this morning, that mortgage case has been going on for 3 years. They know more about that case than what we have because we've only had it for a year. And so it's a great time for us to ask them questions about just exactly what happened. And that's why it's very important for attorneys to be prepared for the questions that we ask. Because we get this thing fresh, and they know it, and that gives us a chance. They get to fill in the gaps, so to speak, that are not necessarily addressed in the briefs. So that's where attorney preparation becomes important to us. It doesn't help us much when the attorney simply regurgitates what's in the brief, because we've read that. It's what they know outside of that that they can fill in the gaps with. That's important. That's a good question, though.
Yeah, to reemphasize, we have briefs from them. And, you know, the parties have submitted legal arguments to us along with their research on the issues. So it's not like the only thing we're going to know about it is what we hear at oral arguments. The briefs are very, very important. I think they're more important than the oral arguments because it's like the whole foundation of your position before the court.
Okay. Up here in green.
My question is, oh, me, talk loud? Oh, okay. I can't talk loud. How hard is it to keep your personal beliefs, personal opinions, your views of social morals out of your decision-making abilities when it comes to cases that may not necessarily reflect the best light of human society?
Oftentimes, the dregs of our society and what they do and how they are treated is the very basis for brilliant rulings under the law. Because how we treat the slightest members of our society is just as important as how we treat the greatest. And so we all, and I can speak for the Court of Appeals, view these cases in a detached fashion. What are the facts and how should we apply the law? What's the law and how should we apply it here? Personal opinion shouldn't get in our way. We deal truthfully, as all professionals do, especially in the prosecution and the defense, with some very bad people. But there are some very noble principles at stake in dealing with their cases. For example, searches and seizures and confessions. They may have done a very bad act, but we, in order to keep society going correctly, following the Constitution, must guide ourselves accordingly. So that's a very good question, but that's what. Okay, another one. There was another one over here. Well, now you've scared everybody off.
Not me.
Okay, right behind you. Right behind you.
When the appellate court hears arguments from two different parties and they're from the same case, but maybe hearing two different arguments, and they're not cited in the other one's brief, can you consider that other party's case when making your decision?
Oh, that happens all the time. Oftentimes, we'll get a pair of briefs, you know, especially in civil cases, the appellant over here, appellee over here, and the appellant cites all sorts of cases, and you think it's like two ships passing in the night, because the appellee's brief doesn't ever refer to any of those cases over there, because they've got their own set of cases that they want us to be convinced with, and so we have to reconcile that. That happens all the time. So what usually happens is our research staff has found a third set of cases, and that's the ones we go with and don't go with those others. That's not exactly true, but that sometimes happens. Yeah. You might be interested in knowing, we will decide the cases we've heard this morning in just a few minutes. So we will know. Usually. That might tell me something right there. But we will decide these cases in a few minutes. We've got a nice room, because we think it's important to decide these issues right after we've heard the arguments. Now, then we'll go back to Topeka or Lawrence and write our opinions. And usually they'll be out, we'll try to get them done within 30, no later than 60 days after that, and out to the parties. We really try very hard to do that. Yes, go ahead.
In situations like this where you decide things so precipitously.
We hope not precipitously. The case has been pending for a year.
After you hear both sides of the arguments, do you ever wonder or go back or revisit cases that maybe you worried that the opinion was wrong?
Absolutely, absolutely. In fact, there are occasions where parties will ask for a rehearing, or maybe on one particular point, or perhaps there's a new case that comes down that affects how we rule on a case. That is not uncommon for us, and we can issue modified opinions. Yeah. Oh, absolutely, absolutely. We have control over the case until the Supreme Court acts upon a petition for review. After we issue our decision, a party has an opportunity, unless it's an appeal by right, and that's very few, a party has a chance to file a petition with our Supreme Court for review. Once that's filed, then we can't do anything with the case until the Supreme Court has ruled on that petition. And that can take some time, but that's, until that point, it's ours to do with as we see fit. And
Now, just so you understand, we've read all of the briefs and the supporting record before the hearing today. So this is not our first look at the matter. So we've spent hours involved in the situation, but the oral arguments can add to that already our knowledge to this point.
Yeah, a few months ago, I was thinking, I wonder how many times I've been reversed, either as a prosecutor, a district judge, or a court of appeals judge. And I came up with probably something less than 50 out of the thousands of cases that I've handled. And I can't say that I think I was ever really wrong, though. However, the Supreme Court has the final word because they are final. And so I may go back and reread that case and say, did I miss something? Usually I don't, because I generally come away saying, no, I was absolutely right. The Supreme Court's wrong. So, but it doesn't do me any good.
that's right. That and $1.50 gets you a cup of coffee. Back there was somebody raising their hand.
Have you ever, or I don't even know if this is actually a decent question. Can you reverse your own decisions in a case? Does that make sense?
From time to time, we will conference a case, and that's what we're going to do after we're done answering questions. And then when we're writing the opinion, your thinking changes. And that happens more frequently than you think. Because once you're taking a little deeper look at things, your thinking changes, and yes, our decision, then we reconference the case, we go over the new reasoning, and if that's persuasive to at least two of the three, then that changes, and then we issue the decision.
Does that change the outcome for the parties?
Oh, absolutely. Absolutely. Of course, they never knew that they lost it to begin with and won afterwards, and they never seem to want to inquire either. The winners don't. Yes, sir, right here.
Do you find that the oral argument is more persuasive than the briefs in themselves? I know those are persuasive, but does one outweigh the other? In other words, you've already prepared and read the brief, you've already read the brief, and you have questions arise, and you tend to discuss these in your oral argument. Is it stronger?
We probably have different views on that depending upon the judges. We have some judges on our court that could care less about oral argument. Everything is based upon that brief. If it's not correctly briefed, you're going to lose, no matter how brilliant you are on that oral argument. I believe oral argument is important because I think it fills in the gaps. Now, having said that, it's not that common that oral argument changes my view. Most of the time, it reinforces my view of a case. But it does happen with such frequency, I value oral argument. I could remember one particular case that I was adamant after I'd read the briefs and the pre-hearing memorandum from our research staff that we had to go this way. But after hearing oral argument, a statement was made by counsel concerning one of the facts, quite frankly, that I didn't understand, and everything clicked into place. And it's like one of those aha moments. And all of a sudden, yes, now I see what's going on, and it just changed my view of the case 180 degrees. That's the value of oral argument, because our goal here is to get it right, as close as we are an error-correcting court. We're not a big policy court. That's for the third floor for the Supreme Court to do. So we need oral argument. Now, like I say, I'm just speaking for myself here, and my two colleagues can answer the question for you.
I would say that oral argument changes my mind in less than 10% of the cases. And that's as it should be, because both sides have had an opportunity to totally brief it. We've got the decision of the lower court oftentimes, and sometimes they're extremely good, and we've got the research of our own research attorneys. So by the time it gets through that and we look at it, read it, talk about it a little bit, you'd be surprised. You know, it would be a surprise if too many cases were changed by oral argument, but some of them are.
I'm one who likes oral argument.
This being his first.
No, I've had several oral arguments in the past as a district judge.
If I just understood you correctly, you receive the briefs, then you discuss it, the brief amongst yourselves before you hear oral arguments?
No, we don't discuss the case until after oral argument, and we conference the case. Yeah, we certainly read it and think about it to ourselves and with our staff, but we don't formally confer about a case until here in a few minutes.
Sometimes a new decision will come down from the Supreme Court of Kansas or the Supreme Court of the United States that impacts on the case, obviously, and that will probably stir us up to talk about it. Sometimes we'll ask the parties to brief a new issue that has just come up, or it comes up after they have done their briefs. But for the most part, no, we don't discuss the cases until we've heard the oral arguments.
There's a question here. Yes.
Approximately how long on average does it take for you guys to receive the case, receive briefings, do oral arguments, and then decide?
I think we get most of our cases done in a year from the day they start. But the starting date varies on how the bean counters count time. Filing of a notice of appeal is significant to the district court, but it has no significance to us until a certain document is called, and then once the record on appeal is shipped up to our court. And that signifies the briefing time, because then we have the rules. It may take a period of time to get the record on appeal done, because some of these trials last for weeks, and it takes a long time to get the transcripts ready, and then the parties have to have those available in order to make their arguments on the brief, because they are required by rule to make citations to the record on appeal. If there's testimony or something like that, they have to give that volume and page cite to us so we can verify what they're saying.
A lot of the delay is us waiting for them to get their briefs done.
Well, and some of the briefs today were filed in December, so it's not very long ago.
Back row.
Okay, so it may be an obvious answer, but I'm gonna ask it anyway. I'm guessing that, you know, with some of the heavier cases that you have, having a sense of humor helps.
Yes.
I don't know anybody on our court who doesn't have one. You know.
Well, they all died.
You have to be able to detach yourself from some of the facts, or they'll eat a hole in you.
Absolutely. We depend, the bar, the attorneys that appear in front of us, becomes smaller every day, it appears like, but sometimes we get some new attorneys in there. We depend upon those attorneys so much because they're very professional. They know what they're doing. They argue the issues that need to be argued. And so it makes, in one way, it makes our work easier because they're so good. But in another way, it makes it more difficult because they're so good. Because we can't get around by saying, well, that wasn't argued, so because they're too good for that. So it works both ways, and I really think that the attorneys that appear in front of us, by and large, vast majority of them do a great job.
Yeah, it's not so much of a problem now, but it has been in the past that the appellate defender's office, those who take the appeals, those who can't afford an attorney, was terribly understaffed with lawyers. And it took a long, long, long time after they got the case for them to be able to get the briefs done. I think they're still understaffed, but it's not as bad as it used to be. So if you want to speed the things up, give more resources to the people who have the responsibility for handling the cases.
Well, I think one more question, and then we'll head off and do our work. Back row, red sweater.
What's the percentage of cases that you hear that are criminal as compared to civil, if you have an idea?
That's a good question. I think it's roughly 70% criminal, 30% civil. We do a lot of, now by that I am including habeas corpus actions filed by prisoners, which we call 1507 actions. Even though technically those are a civil case, I consider them, because they're criminal issues most of the time, how their trial went, because it's a collateral attack upon their sentence or their trial or something of that nature. So I'm going to say, and I could be totally wrong on that, it just seems like among my experience here lately, it's about 70-30. 1507, the statute that permits the filing is KSA 60-1507, and that is a prisoner in custody may file a civil action in their court of conviction that it collaterally attacks the proceeding that sent them to prison or jail or Larned State Security Hospital.
I think we may have one more question.
Yeah, I know you said one, so I debated whether I should. Percentage of appellate defenders that try the case or present the case to private lawyers, and as appellate defendant in the office, can you represent a private individual outside of that?
I don't think so, can you? You don't, do you?
I don't know.
Now, do you have contracts with other lawyers
Yes, private attorneys do.
when you have a conflict? See, oftentimes they'll have conflicts because they'll be representing defendants that were tried together. So they gotta pick one, and then they have other attorneys to represent the others. So, yeah, there's a system for that. Okay, very good. Thank you.